Start. Para. However, we have considered the present petition moved by the petitioner in person. It appears to us that the petition which has been presented before this court lacks in material particulars, and it is also very difficult to discern precisely the allegation sought to be made in the said application. The petitioner has also made a wide and sweeping allegation against a judge of the High Court without giving any instance how and in what manner the said judge has influenced the other judicial officers of the state. Such sweeping allegations against a judge and other judicial officers need to be deprecated in no uncertain term. But it appears to us that the petitioner is a confused person and perhaps has failed to appreciate the consequence of making wild allegations against judicial officers. Even in this application, the petitioner has alleged that this court should pass a direction for making Hindi as a national language because such direction should have been given 28 years ago. He has also contended that he should be compensated for the loss alleged to have been suffered by him without indicating how and in what manner he has suffered losses. He has also alleged that the nation should also be compensated for the loss suffered by the nation from the pockets of the concerned person who did not care to take action against illegal and improper activities by the mill owners and some other persons. Such statements reveal utter confusion and the obsessions of the petitioner. We are therefore not inclined to take any serious view of the wild allegations made against some of the members of the judiciary. Para. We may indicate here that, as a matter of fact, when these matters were taken up for hearing before another bench of this court on 12th August 1994, the said bench, with respect, rightly could not appreciate the precise relief which the petitioner was seeking, and as the petitioner was appearing in person and was making reference about various cases filed in different courts without giving relevant particulars of such cases and orders passed in such cases. Hence, the bench, in its order dated 12th August 1994, indicated that it was not possible for the court to understand what were those cases and against whom the same had been filed because the copies of those order were not available on the record. By the said order, it was directed that the Secretary, Supreme Court Legal Aid Committee would render assistance to the petitioner to project his grievance and assist the court, and the petitioner was directed to approach the Supreme Court Legal Aid Committee for that purpose. It appears that, in view of the direction, a counsel of this court was engaged by the Supreme Court Legal Aid Committee, but for the reasons best known to the petitioner chose to address the court in person, and in his submission he made general and sweeping remarks about the increase in corruption and malpractices gripping the country, seriously affecting the progress of the nation. Para. He also alleged that various smuggling and nefarious activities relating to narcotic and psychotropic drugs were being committed by the owners of oil mill, and various complaints made by him in different law courts were simply dismissed in the absence of the copies of complaints alleged to have been presented in various courts of law and order passed on such complaints. It is not possible to appreciate whether such complaints were maintainable or not, and whether or not orders passed on such complaints were justified. That apart, if an order is passed by a court, a party aggrieved may move against such order in a manner known to law and within the framework of law, as the impugned order of the High Court dated 8th December 1993, passed in civil miscellaneous petition number 63 of 1993, does not call for any interference, and as these petitions do not merit any further consideration, we dismiss the same without any order as to cost. Stop.